My name is Andrew Beshai. I'm a former federal prosecutor, and now I do white-collar criminal defense and internal investigations. My day-to-day varies a lot, but it generally revolves around one of a few different tasks: meeting with clients, assessing new cases as they come in, meeting with the government, whether it's a criminal indictment or a government enforcement action against a big company, and then legal research and drafting, trying to figure out the best way to address the client's needs. I typically see white collar crime, so that includes anything from an individual corporate officer who is accused of wire fraud, to a high net worth individual accused of embezzlement, to corporations that are accused of violating various regulations in their industries, energy industry, landlord-tenant industry, whatever the case may be. A lot. I spend a lot of time with my clients on the front end. The main reason I do that is because it's important for me to learn about who they are as a person, to humanize them. One of the big problems I see when it comes to criminal prosecutions at every level, because I was a former federal prosecutor and I did everything from low-level street crime to large-scale RICO cases to child exploitation cases to white-collar cases. And I see the same thread play throughout, which is a lot of times the government doesn't know who this person is, the accused, who they are as a person, as a human being. And while that's not really a legal consideration, it plays a lot into charging decisions, sentencing decisions, and what they might ultimately get offered as a plea deal. The underlying reason behind this is that fundamentally, the government is trying to protect the public. And so they take a very conservative approach to charging decisions. They see a potential threat, they see someone who is engaged in misconduct, and they do as much as they can to stop that misconduct, to get restitution if it's a financial crime, or to protect the public. By humanizing the defendant or the accused, you can kind of walk back some of that narrative that the government has already formed in its mind and show them that this is a real person who either didn't do anything wrong or took a few missteps, but is worthy of rehabilitation and can become a contributing member of society. So at the beginning, it's important to get as much of that detail from them as possible. One of the most common misconceptions I see among people who are being charged with a crime or have had a run-in with law enforcement is that they overestimate two things. First, they overestimate how much right the government has to access your material, whether it's your home, it's your devices, or the information in your head with questioning. There are really, really strong limitations that the Constitution imposes on the government's ability, and that includes police officers, FBI agents, state attorneys general, any government entity in a criminal prosecution has significant limitations on how much of your stuff it can access. I think because of our ingrained desire to defer to authority, we generally overestimate how much they're allowed to access, and we give consent. Always remember that you have a right to privacy and you have a right to remain silent, and by giving up those rights, you're not doing yourself any favors. So that's the first main misconception. The second major misconception I see is overvaluing how much the government actually wants to help you or be your friend. This isn't to disparage any law enforcement officials. I think most of them are very hardworking and are trying to do the best they can. But it is to say that one of the most common strategies they use is an effort to befriend you and induce you into believing that they're on your side, and that if you cooperate, they're going to help you out. As a corollary to that, a lot of times they'll overplay their hand, but you don't know that. So they'll say, we already have XYZ on you. Your friend has already told us XYZ. We have evidence that shows XYZ. And they don't have to tell you the truth, right? You don't have a right to the truth from them. So a lot of times Based just on that information, people facing accusations feel the need to fold immediately. Really, what these two common misconceptions boil down to is an over-reliance on what government can do and what they're willing to do to help you. The answer is to get an attorney as soon as you can. One of the critical junctures that happens in the criminal justice system is something called an indictment. That is essentially a piece of paper, or multiple papers, but it's one document that charges you with a crime or a series of crimes. And for a lot of people, they don't know that they're about to get indicted. The first inkling they get is when they get arrested. I'll address that in a moment, but there are situations where you do get a sense that you might be getting indicted. There's a couple of situations in which the government does certain things short of an indictment that might put you on notice. They might serve a search warrant at your home, but not arrest you at that time. They might issue a subpoena to you, to an employer, to someone in your network, asking for information about you. If you catch wind that an indictment might be coming down the road, and again, the way you would be on notice of this is through some occurrence, some contact point you'd have with law enforcement, a search warrant at your home or place of business, a subpoena that comes to you or an associate asking about you, get an attorney as soon as you can. You'd be surprised how often an attorney who specializes in criminal law, white-collar prosecutions, can get on the phone with the charging agency and try to work something out even before an indictment. That can save you a lot of hassle. At a minimum, you'll have someone to protect you from the moment of an indictment, if that's inevitable. If you're not fortunate enough to have any forewarning and the first inkling you get is when you get arrested, get a lawyer immediately and do not say anything to law enforcement. I know sometimes that goes against our natural instinct to A, defend ourselves, prove our innocence, and B, defer to authority, but I've been doing this for almost a decade and I have rarely, if ever, seen it benefit the person who's speaking. A lot of times, an attorney can help see angles in your case that you just don't have the training to see. They can see evidentiary gaps, they can see deficient procedures that maybe they can challenge, a search warrant that wasn't obtained in the right way, a cooperator who is really shady, certain things that could really help you out. You need to give the attorney a chance for them to explore that and let that play out. By speaking immediately and giving your side of the story, you're essentially short-circuiting that process. The attorney now doesn't have an opportunity to give you the best defense because you've already put something out there in the record that no matter what weaknesses might come up through the attorney's research in the prosecution's case, you've already kind of given them this advantage. So it's always best to seek legal counsel and not speak. From the indictment to a trial or plea and ultimately to sentencing is a long journey. It can take years and years. But there are a few things that I've seen clients do that has made the process a little bit more bearable and given them the best chance at the most favorable outcome. First, try to avoid communicating with people who've been named in the indictment with you or co-defendants. Second, if you've been charged with certain conduct that you're still doing, stop it immediately. Third, if you've been charged with something that you can rehabilitate, a drug problem, a gambling problem, anything that you feel like you can seek help for it. That's going to look really good to the court down the line. It's also going to help you potentially get a better plea because now you're showing the government that you're not a safety threat, that you're not a flight risk, that you are someone who's committed to being rehabilitated. And fourth, stay in constant communication with your attorney who is spending a lot of time working on your case. Sometimes they get busy, but it's incumbent on you to reach out if you haven't heard it in a while. And then the last thing, try to find a way to maintain your mental health, because one of the most challenging things that I've seen clients face is just the emotional toll it takes to live in that limbo for as long as they have to, and to go down those mental paths of, well, I shouldn't have done this, or I could have done this. That's not going to be helpful at that point. It's much easier said than done, I acknowledge that, but doing anything that you can to maintain your mental health, get into habits and routines, because you will get through this. I mean, people get through this all the time. Hundreds of thousands of people are being charged as we speak, and they're getting through it, but it's not easy. What motivates me as a lawyer is honestly just doing a good job for people. I have family members who've had run-ins with the criminal justice system. I have a past as a civil rights attorney before I came into criminal law. I was a middle school teacher. I've just been part of a lot of different systems: criminal justice system, education system, and people are running up against these systems and they don't know how to navigate them. And it brings me a lot of joy to be able to just help people walk through the system. I think a common misunderstanding about what criminal defense lawyers do is they get people off, but most of the time we're not working some miracle to find some crazy loophole. Most of the time we just are ushering people through a system in the most favorable and humane way possible. We know pretty much every step in the system. We've seen it over and over and over. We have relationships with government agencies that we can leverage. And we're just helping you walk through something that we walk through every day. It's your first time, but it's not ours. That can mean a lot of things. Finding a good legal argument, humanizing the client so that they get a more favorable plea, making a really, really strong pitch at sentencing to show how far this client has come. It's not always about, again, getting the person off. It's just about having them feel seen and heard, and then showing the person we've come to know to the government agency bringing the action, in the hope that it will bring about a favorable outcome.